Are we waiting for a video to be played?
Yeah,
Yes, ma'am.
the way it will work is Kirti will first share like a video, but and I'll give some intro marks, give an intro about L2 and then invite you over. If we can
Sure.
wait for another 5, 6 minutes until
No problem.
we start.
No problem. Just let me know when I have to begin.
And in terms of logistics and all the rest, but we tend to have a very active, participant base. So if there are any questions and all that, we'll try not to interrupt you. But if there is some question which is relevant to what you're presenting, we might just, call that out to you. Else we can take questions at the end.
No problem.
Sure. Thanks. So Kirti, we are, a minute past. Shall we get started?
Yes, sir. Actually, I'm trying to share, but there's some problem with my end. I'm unable to share. I'm just like the download slide is only opening up. The video isn't coming up.
No worries. Then let's go ahead. Hopefully we'll fix it, at the end.
Sure, sir. I think we can start now then.
Yeah. Sure.
Good afternoon. This is Mohammad Maz Hussain from Department of Business Administration, AMU Aligarh.
Yeah. Hello, Mr. Hussain. Thank you so much for joining, and thank you to all the attendees. I am Hemang Shah. I'm the co-chair for the National IPR Council at ASSOCHAM. I also work for Qualcomm. I'm joined by my colleagues, Anirban Mukherjee. We also have a speaker, Meghna Chandorkar, and I'll be introducing her in more detail later on. So today's, session is going to be on the process to the registration procedure of copyrights in India. And as such, particularly with the IPR Council, we want to spread the IPR awareness over here. And today's material, is being sort of brought to you by a program called L2 Pro India. It's an initiative that I've been involved with in my other hat. And the journey for L2 Pro started in working with startups in India since 2016. We saw that the IPR awareness will vary all over the place, right? There are some people who are very familiar with all the IPR concepts, but quite a bit of the number of folks, did not have an appreciated understanding of what IPR means and how they can leverage it, for their businesses. So we took these observations in interacting with the startups, and we discussed this with the DPIIT and with the academic partners of NLU Delhi. A course was developed called L2 Pro, which means Learn to Protect, Secure, and Maximize Your Inventions. It's a completely free course available on the web as well as on apps. What this course does is it helps you understand the various nuances about intellectual property rights, mainly how you should protect innovations with patents. As we'll learn more from Meghna later, how we can use copyrights not just to protect software, but even other aspects of your work that you consider as innovative. How you can develop trademarks. Overall, how you should obtain value from your R&D efforts, and mainly, how you can bring your innovations quickly to market. The course is split across 3 different levels: basic, intermediate, and advanced. In my opinion, everyone should go through the basic level because it tells you the most common and the most powerful IP rights that we have, especially in India. Then for the ones who are interested, they can go to the intermediate level where they can get a more behind the scenes understanding about the different IPR nuances. And finally, we have the advanced level courses which take you to depth about certain IPR matters. Now, at the end of each level, there is an assessment, and the assessment is based on a case study. So we try to make it fun and relevant to startups. So even the course material is presented in a way that you can absorb it better. There are intro videos, there are summary videos, about 2 minutes duration roughly each. So if you give 5 minutes to the course, you can learn about 60-70% of the course material. And the assessments are based on a case study, which is more like, hey, here's a situation a startup is going through. What will you do if you encounter such a scenario? So it's not just to test you on just the factual aspects, but it's more of how we would apply it to your work. The goal of the program is to make sure that there is a light bulb which goes on in your head which says that, hey, here's something which I need to protect. Here's one IP that we possibly can consider for filing across the different IPR rights, and you can either proceed by yourself or contact your IP depending on what the case may be. The folks who complete the assessment successfully will get a certificate which is provided on the spot, and this certificate is provided by DPIIT, by NLU Delhi, and by Qualcomm. Now, my colleague Anirban has been sharing the links for the program in the chat box, so please take a look at it, go through it. Again, it's completely free. It's written for the innovator in all of us, particularly directed towards startups and SMEs. Now, today we will discuss the various nuances as applied to copyrights. And to take us on this journey, we have Meghna Chandorkar. Meghna is a partner at TMT. It's a very reputed firm. She's an alumnus of ILS Law College in Pune. Meghna has 13 years of experience as an IP and a media and entertainment lawyer. After graduating in 2009, she has worked with IP teams of leading law firms with a strong focus on trademark and copyright law as an in-house counsel for a music company and for a broadcast media and entertainment company. She has also completed the Young Leader Development Program from MICA Ahmedabad. Her core areas of expertise include structuring, drafting, and negotiating agreements, providing advice and opinions pertaining to the creation, maintenance, protection, acquisition, and exploitation of IP rights. She is skilled in copyrights, media and entertainment, broadcast, trademark, and contract law. And not surprisingly, she has been recognized as a professional whose advice is valued in providing creative legal solutions and advice to clients. So Meghna, thank you, for joining us today, and we are looking forward to learn from you.
Thank you for the introduction, Hemang. Should I start then?
Yes, please.
Great. Okay. So today we're going to deal with copyright as a form of intellectual property protection that is available for all people who are creative and who come up with original works. So we can start with what a copyright is to begin with. A copyright, as I said before, is a form of protection, which is an intellectual property right, which is granted to the creator of an original work. So the types of works that are granted protection under copyright are literary works, dramatic works, musical works, artistic works, and then it also extends to combinations of works which are cinematograph films and sound recordings. What does copyright give you when you apply for protection or when you create a work? What you're given is the exclusive right to use that work and to do certain acts in respect of those works. So Section 14 of the Copyright Act basically gives you the right as an owner to reproduce the work, to adapt it, to translate it, to make copies of it, to communicate it to the public. All of these rights are granted to you as an exclusive right when nobody else can do these acts in respect of the work that you have created. The main criteria to be able to claim that a work is owned by you and that you own copyright in it. Sorry. Hello.
I think it was someone accidentally pressing unmute.
All right, sure. So the main criteria, Alka, if you could just go back to the first slide, we'll come to this later. The main criteria to be able to claim copyright over any work is the fact that it has to be original. It can't be copied from anywhere. You cannot take somebody else's work and claim that it is your own. You have to be able to prove that you have come up with this originally. Now, what is granted protection is not a unique idea, but it is the expression of the idea. So if you have a general idea of a love story, you can't copyright and protect a love story in general. It is the expression of that particular idea, the unique manner in which you put a story and a flow to it, over which you can gain copyright protection. So what that means that anybody else can also create an expression of the same idea, provided that it is not identical or substantially similar to yours. So as we said before, the types of works that copyright protection extends to are literary works. Alka, if you could just go to the definitions, then we can explain what all the types of works are. Perfect. Okay. So literary works, which include computer programs, tables, and compilations, including musical databases. Literary works are also dramatic works, but dramatic works, while they are in writing, are scripts, screenplays, stories that you would have written for the sake of drama, for the sake of dramatic expression. So anything that is in a written form, which is a literary work, will be filed as a literary work. If it qualifies as a screenplay or a script or a story, it will be filed under a dramatic work. All other types will be a literary work. And software and computer programs, your source code and your object code, are also covered under literary work. So when you're filing an application, it becomes important to categorize the work that you are filing an application in respect of. The second type of work is a musical work. So now musical work is not a song or a recording of the song. It is the written expression of the musical notes of the musical composition. So that is what gets protected as a musical work. A music composer can reduce the musical composition to graphical notations and then register that as a musical work. The third type of work is an artistic work. Artistic works, by the very name, they're artworks, paintings, sculptures, drawings. Even architectural works fall under artistic works. And when you've created an artwork, you can register it as an artistic work. The next two come to cinematograph films and sound recordings. Now, what is different about these two from the earlier ones is that both of these are amalgamations of various kinds of works. For example, a sound recording comprises of literary works, which is the lyrics of the song, a musical work, which is the musical composition of the song, singers who are singing the lyrics, which is a performance. The type of work over there is a performance. And all of these, when performed, are recorded together. And the recorded version is called a sound recording, which is entitled to a separate type of protection on its own as an amalgamation versus the individual protection that you would get over the lyrics or the musical composition. Similarly, for a cinematograph film, it is also made up of various types of work, starting from a script, actor performances, sound recordings, musical compositions within it. So all of these together form the cinematograph film. The cinematograph film itself can obtain copyright protection as an individual work, and the individual works under it are also capable of copyright protection. But when you want protection over the film as a whole, when you apply for copyright registration, you will apply under a cinematograph film. Okay, this brings us to the term of copyright in each work. Now, while copyright exists from the moment of creation, unless you put it out there in the public, nobody will know about it and nobody will be able to protect it. So there is no sense in you protecting it per se, because it's not being exposed to anyone. So technically, your term of copyright starts from the moment that it gets published, which means from the moment it is made available to the public. Now, in case of these individual works of authorship, which are literary, dramatic, musical, and artistic works, where an author has to create that individual work, the protection, the term of protection of copyright will commence from the time that you publish it for the entire lifetime of the author, plus 60 years after his death. And for sound recordings and cinematograph films, from the moment that they are released to the public, which is their date of publication, from the year starting after the date of publication for a period of 60 years is when you can claim copyright protection in these types of works. What happens after the term of copyright protection expires? All these works come into the public domain and can be used by anybody in the public. The reason that a term of protection is given to copyright owners is so that for that period, they can enjoy exclusive rights as the owners. They are given that economic benefit to exploit and utilize their copyright to the exclusion of all others. They have the right to grant licenses and assignments to allow other people to use their work in permitted manners. So this is basically an economic benefit that is granted to the author or the owner of copyright. Okay. Now, the next question is registration of copyright mandatory? As per our law, no, it is not. You have copyright in your original works from the moment that they come into existence. But there are a lot of advantages that come along with registration, which is why we always recommend to authors and owners to get their works registered. The main and most important advantage of registration is the registration certificate that you are able to get in your name works as proof of the creation of that work, the existence of that work, and proof of ownership of the work belonging to either the author or the owner. Apart from that, there are several other instances where ownership, where registration is going to come to your benefit. If tomorrow somebody copies your work and uses it as their own, you are able to go to court and prove your ownership by displaying a registration certificate versus having to prove that you are the creator and the owner of the work. So what happens when you go to court is if you don't have a registration certificate in your favor, the burden of proof falls on you where you need to be able to establish your rights in the work. You will have to make a case proving that you are the creator of the work or that the rights in the work belong to you and that the ownership vests with you, and then you will have to be able to say that somebody else is copying your work. However, if you have a registration certificate in your favor, the courts will presume that you are the owner. You won't have to prove this ownership to anybody. You will be able to display a registration certificate and assert your rights. That is the biggest advantage of having registration in your favor. It acts as a public record of ownership. What comes next is many businesses, when they are investing or making investments in, sorry, does somebody have a question?
Yeah, Mr. Nagendra Prasad, please mute your mic, and to all attendees here, kindly mute your mic. Thank you so much. Yeah, please, Meghna, kindly go ahead.
Okay. It also works for valuation of copyright. Now, for example, that doesn't mean that if you don't have a registration, your work won't be capable of being valuated. There'll obviously be a value that is assigned to it, but registration increases the value because whoever is valuing your work and is thinking of investing in your business will know that tomorrow, if a situation of infringement comes up, there is a registration certificate and that is proof of ownership. So valuation of the work also goes up. And slowly, what we're realizing is that many businesses, while it is not a statutory, it's not mandatory to register your copyright, it is becoming more of a process that companies and businesses are following, where they will ask you to provide a registration certificate before proceeding in terms of a commercial transaction. One of the one instance over here that where a registration certificate will help you is if you have a registration certificate, you can register it with the customs office to show that you are the owner of that work to prevent the import of unauthorized works coming into the country.
ভাই বলেন আপনি ফোন করেছিলেন ভাই আচ্ছা আমাদের ক্লাস চলছিল তো ফোনে আর একটা ফোনে ক্লাস বলুন ভাই হ্যাঁ ভাই
Kindly mute your mics.
ঠিক কত টাকা?
I, Kirti, can you mute Mr. Akhtaruzzaman Molla's mic?
Yes, sir, doing it.
আমি 21 লাখ টাকা পর্যন্ত হিসাব করেছিলাম। আমি 21 লাখ পর্যন্ত হিসাব করি, তারপরে আর হিসাব করিনি আর।
Or you can probably remove him from the webinar.
তারপরে আমি খুচকাজকে দিয়েছিলাম, তারপর হিসাব করিনি, তারপরে 25
Sorry, Meghna. This is
No problem. That's fine.
actually we have seen the webinar format to be very interactive, so that's why we have preferred this.
নটা পেপার দেবে?
I'll just continue once.
Yeah, please. And Kirti will try and mute Mr. Akhtar
হ্যাঁ হ্যাঁ হ্যাঁ।
Jaman Molla or remove him from the webinar.
Sure.
Yes, sir, it's done, sir.
All right.
Please go ahead, ma'am.
All
Okay, sorry.
No problem.
Okay. Yeah.
Okay. So does anybody have any questions so far, after which we can move to the process of registration and how you actually go about registering your copyright?
There are no questions, Meghna. You please go ahead at this point.
Sure. Okay. All right. So
Ma'am, Meghna ma'am, sorry, I have a question. Suppose now we are doing research work and publishing papers in the journals, so that also we can do copyright register.
you can obtain registration over whatever you create as long as it is original.
It is original, ma'am. My research work I have given for publication in the
Correct.
journal.
Now, have you created this research work on your own, or have you done it because a company has employed you or engaged
no.
you?
No, on my own, on my own.
If you've done it on your own, it is capable of copyright protection. You can make an application and apply for registration.
Okay, ma'am. Okay, ma'am. Thank you, ma'am. God bless.
Thank you.
Ma'am, I had another question.
Sure.
Srinivas here.
Sure.
Ma'am, how is the copyright ownership verified? Like if I claim to have created a content and I want to register for copywriting, then how is my claim, verified that I am authentic?
Okay, so when we come to the procedure of registration and the documents that are required to be submitted with your application, this question will get answered over there and become a little clearer. Basically, when you are an author of a work, there is no issue because you will be able to prove that you are the author of the work because you have created the work. But for example, with sound recordings and cinematograph films, where it is a combination of many other works, you will have to obtain NOCs from all the various people who have contributed to that particular work and file those NOCs along with your application. But we'll come to this in detail.
Okay, ma'am. Thank you.
No problem. All right. So, process of registration. Now, registration of an original work can be done with the Copyright Registrar under the Copyright Act. The whole process takes generally about a year to take place for your application to proceed to registration, unless any issues creep up, in which case the process can take a bit longer. What basically happens is, the first step to the process of registration is you file an application of the work. When you file an application, you can file an application as an owner, as an author of the work, or as an owner of the work. Now, what is the difference between being an author and being an owner? An author is a person who has created the work and has authored the work. An owner is somebody who has obtained the rights in the work from the author. There are certain situations where the author is obviously the owner of the work. There is a distinction that is created when somebody purchases the right and takes an assignment from the author and becomes the owner of a work by executing either an assignment agreement or because of the commercial transaction and the manner in which the work was created. So for specific types of work, I can commission somebody and engage them to create a work for me and the valuable consideration that I pay them is sufficient for that owner, for the ownership in that work to vest with me. In employment situations, it is always the employer usually who is the owner of the work. But unless there is an agreement to the contrary where the author has retained the ownership of the work, the author is always the owner of the work. So it basically depends on what has happened so far, where the ownership of the work lies. So if you are filing an application as the owner of the work, you will have to show an assignment agreement or an agreement to show how the ownership comes to vest with you. And if you are an author of a work, you can file the application as the author and owner of the work. Now, this can be done through your authorized agents. You can either file an application physically or you can do it digitally through the official website of the Copyright Office. For registration of each type of work, a separate application must be filed with the registrar along with the particulars of the work. And there is a fee as well that has to be paid, a government fee, where for different types of works, different types of fees are applicable. We'll take you through the schedule of fees at the end of this. Now, the first step that happens is something called a formalities check. So once an application is received at Copyright Office, a formality check of the application is carried out to ensure that the basic requirements of the application are complied with. Sorry.
Please go ahead, ma'am. Please go ahead. Please type your questions in the chat window at this point.
All right. Now, if an application fails the formality check that is conducted by the office, a letter will be issued to the applicant asking you to furnish whatever the necessary requirements are to basically make sure that the application is in order. In such, so basically over here, until the applicant replies and provides all the necessary requirements to make the application capable of being processed, these applications are then termed as work awaited on the website of the Copyright Office and will be pending until you reply, giving the particulars that are required to clear the formalities checks. At the end of the step, once the formality check is passed, once you have replied with all the information that was required, you will get something that is called a diary number, which is the equivalent of an application number. And this is the number that you can use to check the status of your copyright application. Step 2 of this entire process, Alka, sorry, yeah. Is there any way for you to zoom in and show the steps in larger detail? If not, that's fine. I was just thinking that others can view it as well. Okay.
Yeah.
Okay. The second step over here is examination of the application and waiting period. So basically, once the diary number is issued, there's a 30-day waiting period. In this time period, the copyright examiner will review your application. And there is also a separate reason for the 30-day period. It is so that objections from the general public can be made to say that this copyright should not proceed to registration. There is a slight issue with the second part of the objections part of it because, for example, in the trademarks application process, it's very streamlined. The minute an application is accepted, it will be published in a trademarks journal, and then there's a 3-month waiting period for you to file your objections. The problem over here with the Copyright Office is that the digitization is happening extremely slowly. So the journal advertisements are not being published on a monthly basis, or so viewing what has been applied for becomes difficult. So in most cases, this entire objections process that should take place doesn't take place, and the scrutiny is done only at the registry level. So I'll take you to that, and I'll tell you what the implication of that is as well. So basically, the application is examined. If no objections, so we'll come to the objections part of it later. Now, if no objections are raised and if objections don't come, the examiner, the copyright examiner, goes ahead and reviews your application and scrutinizes it to find any further discrepancies. Even after the formalities check pass, there's one more level of scrutiny that happens. Now, if there's no fault and if everything is in order, it's a case of zero discrepancies, and then you can move on to the next step, which is registration. However, if further discrepancies are found, then a letter of discrepancy is sent to the applicant, and after you send a reply as the applicant, a hearing is conducted by the registrar to understand why your application should move forward. Once these discrepancies are resolved, you can move to the next step, which again would be registration. Now, the parallel process which is supposed to happen, which unfortunately does not happen due to the lag in the digitization of the registry, is that the application should be capable of viewing by the public, and objections and the public is able to raise objections against the application. Once an objection is received, once an objection is received from a third party, what basically happens is that the copyright registrar will issue a letter to both parties and ask both parties to come for a hearing and basically hear both sides to see why it should be objected and why it should proceed to registration. Now, if the objection passes and if the registrar is of the opinion that the objection is a valid objection, the copyright application gets refused over there, and that's it. That's the end of the process. But if the applicant is able to argue his case and convince the registrar that his application should proceed to registration, then the objection is cancelled and the application proceeds to registration. The third step, which is registration, is basically a small process where the registrar may ask you for a few additional documents, and on being completely satisfied, he will issue a registration certificate to you, and the work will become a part of the register of copyrights and be displayed to the public. Basically, a notification will go out to the public that this work is now registered in the register of copyrights. Now, what happens if your application is refused, or if the person who has filed an objection wins and your application is either refused by the registry itself or refused because of the objection being filed? Your recourse over there is to file a suit in the High Court, the relevant High Court of relevant jurisdiction, and ask for an appeal against the registrar's decision. This is the only recourse that is available to us right now. If the suit is filed in front of a single judge, it can be appealed to a division bench. But if it is filed in front of a division bench, their order will be final over here. Okay, now Alka will take over and take you through the step-by-step process of filing an application and the documents that are needed. Alka, I think you'll have to skip a few slides and go ahead because we've covered these 3 steps.
I'm Srinivas here. I had one doubt on the application process.
Yes.
If I would like to copyright training material based on some global specifications that I have made. Now, once I'm granted copyright, if I have to update the training material, does the copyright still hold, or do I have to do a re-copyright? How do I update my content of my training while maintaining copyright?
When you modify the work and you make changes to the work, eventually you will have to file a new copyright application to register the work in its new form. What you're basically doing is changing the work, you're modifying it and you're adapting it, which you're entitled to do as the owner, but you will have to file a new copyright application to register the work in its new form.
Thank you.
Mohammed, I wanted to know whether this copyright thing is valid for biological sciences work also?
When you say biological sciences work, do you mean research work in the area of biological science?
Yes, yes.
Yes, the only criteria for you to be able to register your work, to apply for registration and to claim copyright, is that it has to be original.
Okay.
So if it's not copied, if it is a product of your own hard work and your own, if it is an original product that you have created, you will be able to apply for registration.
Madam,
So
previous
this will
to the
come under copyright, or this will go under IPR?
IPR is a general umbrella. There are various types of intellectual property protection.
Yeah. Okay. Yeah. So this is a part of that. Yeah. I'm sorry. Okay. Right. So this will be covered under copyright.
If it is in the form of a
A
written
product,
work,
for example.
if it is in the form of a written literary work, if you have written it as a thesis or as material which is reduced to a literary work, then yes, you can register it as a copyright. If it has any sort of scientific process involved in it, which is a novel or an innovative process, then you will have to file a patent application.
Okay. Okay. Fine. Thank you so much.
Meghna, I just wanted to ask one thing. Hello.
Yes.
Actually, like as per NMC, we have to have logbooks for each department in medical. So, like every department has made their own logbooks. So, can we go for the copyright of those logbooks?
What is contained in these logbooks? You can give me a little bit of a better understanding. What is comprised in the logbooks?
Like in the logbooks, we like it's just like a journal of what we teach them, like about the article postings. They
Dr. Mangal,
all
I'm sorry,
that.
but your voice is breaking. I'm not able to hear you clearly.
Actually, it is like a journal
Okay.
of what we teach them, teach the UG students.
Okay.
So
This
we have
teaching,
compiled
this
those
teaching
logbooks.
material, the teaching material that is a part of the journals, is this taken from other existing published books, or is it teaching material that you have come up with on your own?
No, like we have taken things from other journals and we have got modified them.
Okay, see what you're doing, where you're doing it in the course of education for the purpose of educational reasons and in the course of instruction, that is something that falls outside the scope of infringement. That is something that is called fair use, and you can do it. But you can't go and protect this work as if it is your own work if you have not come up with it originally. That said, copyright is granted to compilations of work. So if there's a unique manner in which you have compiled work, then over the compilation, over the arrangement, you can claim copyright protection, but you won't be able to claim copyright protection over the content if the content belongs to somebody else.
Okay, so we can go for copyright. And the other thing is that like we are
no,
like it gets published under.
Sorry, I'm so sorry. If the work is compiled in a unique manner, then yes. But if it is just copied from other textbooks, then you can't claim copyright over the content. So the written works themselves, you can't claim copyright over because you have taken them from other sources.
Okay, even if we have edited them.
But only the copyright owner has the legitimate right to edit something. So if you have edited it, you are doing it without permission from the author. Because you are doing it for the purpose of educating people, that will fall outside the purview of infringement and it will be deemed fair use. But you can't go ahead and register it as your own work because you have not taken permission in the first place.
Like we haven't copy pasted it from someone who has copyrighted it. Like the NMC provides us a template, like that this should be done, a template for it, and then on the basis template we have.
So, ma'am, I'll try and give you an example which will maybe make it easier to understand. imagine if you had created research and written a paper on your own, and another organization or person or entity takes your material for the purpose of training. So it is fair use. They are allowed to take it for the purpose of training. But tomorrow, if they make a few edits to it and make a few modifications to it and go ahead and protect it as if it is their own work, then your copyright in your original work would be infringed. So you can't make a few changes and then claim that you are the owner because you're making minor modifications, because you're taking somebody else's work and making a few edits to it and trying to say that it is your own. So if you see it from that perspective, if you see it from the perspective of you being the author, your right would be infringed.
Okay. So can we get it copyrighted in the name of university, of our university? Because our university has got that logbooks made for their medical students.
If the university has got the books made, in the sense that if the university has gotten authors to write the books and then gotten them published, then yes. But it all depends on the facts of the matter. Like, has this been picked up with permission? Has it been written for the university so that the university can publish it? What are the facts surrounding the matter?
Okay, so it can't be like if we are following a template and then moving on it, then because we are following a certain template, so we can't get it copyrighted.
No, if you have written the works originally and
Following
gotten them,
we can follow a template, but it has to be written originally.
Dr. Shweta, we'll pause the question now, and I'll request Meghna to continue with her presentation. Thank you so much. Thanks so much for your question.
All right. Okay. So Alka, will you please take over and take them through the copyright registration form and the requirements for each type of work?
Sure. If I may interrupt, Meghna, hello, I'm Anushri Gupta. I have a question that is there any privilege given to the literary work for children?
Ma'am, please don't mind. We will continue with the presentation. We will have time at the end. We will not take any Q&A now. Thank you so much.
All right. Thank you.
Yeah.
Okay. So in furtherance to what Meghna was saying, of course, you can file the application physically. That is, you send your application, your documents that are necessary for application via post to the registered office of the Copyright Office. But you can also file it online. This is the procedure to file online, wherein for each application, be it literary work, musical work, any kind of work, requires Form 14, which is the base of application, and you have to fill Form 14 depending on the kind of work you're applying for. This is the 4-step procedure to fill Form 14. One, you have to, of course, enter the details of the applicant. Press save. Step 2 would be to upload the signature. Usually what we do, the signature of the applicant is uploaded in JPEG format. Then the particular statement of particulars has to be filled. I will, as we move on, I will show you what the statement of particulars should include. Then, if at all necessary, statement of further particulars also has to be uploaded. And that will conclude your procedure to file Form 14, after which, of course, the payment has to be made. After this payment, the diary number, as Meghna mentioned, will be generated. And basis this diary number, in the future, you will be able to track the status of the copyright application. Now, these are just general rules of thumb when uploading works. One is that for artistic works, it needs to be uploaded in PDF and JPEG format. For sound recording work, it has to be uploaded in MP3 format. For literary, dramatic, music, and computer software work, it has to be uploaded in PDF format, and it has to be less than 10 MB. Now, especially for computer software, the PDF that contains the source code and the object code has to be readable, in the sense that it has to be computer readable, and it cannot be blocked, or no portions of it can be redacted. After which a general acknowledgement slip is generated, and that
Sorry, so sorry for interrupting you. I just wanted to add a piece of information here. Now, if a software of yours is something that you don't want to disclose, where it forms a trade secret, where you would not want somebody to get the entire code, in that case, don't register it. Because then you're putting it as a part of the application and then it becomes a matter of public record. So it's just a piece of advice over here where if you don't want the source code or the object code to be divulged to the public, then in that case, don't register it. Sorry, Arpa, you can go on.
problem. Actually, in addition to Meghna's point, like we discussed, registration is not mandatory. And from the time copyright is created, ownership is created within it. So, of course, I mean, this source code, you will always be the owner of it, but you need not register it if you want, if it is a trade secret. Okay, continue.
There are advantages which we've discussed before. So those advantages, I think, would be applicable, except maybe in this case where you're trying to keep something proprietary and keep something within a company.
Yes. Okay, moving forward, you will of course get an acknowledgement slip, and this then needs to be posted to the Copyright Office. These are the documents necessary for different kinds of work. Of course, for each kind of work, like I said, Form 14 has to be filled. The way Form 14 is filled, of course, differs from work to work. For cinematograph film, you have to upload or send 2 copies of the work, only one if the work or the film itself is published. That means if the film has released. The statement of particulars is not compulsory in this scenario. If the application is being made on your behalf by your lawyer or by any other individual, of course, a power of attorney is required. Additionally, no objection certificates are required from the contributors of the cinematograph film. Like Meghna mentioned, films are a culmination of various underlying works which are themselves capable of copyright protection. In that scenario, NOCs or agreements with these contributors will have to be submitted with the registry to basically show that these people do not have any objection to the application of the of copyright for the film. If of course the film is published, then the publisher the publisher is other than the applicant himself, you require an NOC from them. A important point here is that Form 14 and the SOP, if it is being filed, has to be signed by the applicant, as against in the trademark procedure, it's usually signed by the lawyer himself. This is for literary, dramatic works and computer software works. Duly filmed Form 14. This Form 14 will contain the application or the declaration form, the statement of particulars. Of course, in a case of application for a computer program, it has to be accompanied by 2 copies of the source code and the object code. Like I mentioned, the source code and the object code have to be provided in digital medium, that is in machine readable format, not written or text form on paper. A statement of further particulars also have to be provided. The power of attorney, like I said, if it is being filed through an attorney, then 2 identical and original copies of the work. Of course, the title of the work must appear on that copy. And all right. Sound recordings, it has to be, of course, again, Form 14. So these documents are same for each of these works. I'm just going to gloss through them. The NOC copies of work.
Please go ahead, ma'am.
Please continue.
Okay, and the statement of purpose. For musical work, again, the same thing. Here, actually, but one needs to take care that the work is shown in the form of graphical notation, that is in sheet music. It cannot be lyrics, or it cannot be the things that would fall under sound recordings. For example, Western swaras or the cue sheets that are given in the film industry usually fall under this category.
So basically, as I had mentioned, if it is a recording of music, it becomes a sound recording. But for the musical composition to be protected on its own, it'll have to be reduced to graphical notations in a written format, and then you can file an application for a musical work. But the minute you produce a recording of sounds, that will go under a sound recording.
Yes. Thank you, Meghna. Artistic works, of course, Form 14. This now is divided into two parts. One, artistic work which is capable of being used in relation to goods and services. And second, if it is not capable of being used, in this scenario, even the price for the fees for these applications is different. In case of it being capable of usage is 2,000 rupees, and not being capable is 500 rupees. In the former, under Section 45 of the Copyright Act, this work will have to be accompanied by a search certificate that is provided by the Trademark Registry, and you have to file file for a search certificate from the Trademark Registry, and that has to accompany your documents when you're applying for copyright here. Secondly, if your work is capable of being registered as a design, in that scenario, an affidavit has to be provided with the document stating that you have, of course, not applied for a design. And thirdly, if it is capable of being reproduced under an industrial process, it cannot be reproduced more than 50 times. Of course, if the, yes?
Alka, sorry, just jumping in over here. The search certificate issued by the Trademark Registry in pursuant to section 45, let me just break that down. If you have created an artwork which you want to use as a logo, as a part of your brand name, then it falls under a trademark because you're using it as a logo, as a part of your brand name, and it can be registered as a trademark as well. But the artwork itself can also be registered as a copyright. So what basically happens here is if you want to register that artwork as under copyright, then you need to go to the trademarks registry and have a search conducted so that the trademarks registry can determine that no other logo has been protected which is similar to the artwork that you are intending to file as a copyright. Because what would happen in that scenario is that a similar looking work would get, someone would get copyright protection of that under the Copyright Act, and another person may have already gotten trademark protection for a similar looking artwork under the Trademarks Act, which would create a conflict in rights, which is why the Copyright Act says that if you want to protect an artwork as a copyright, which is also capable of being used as a trademark, that is in relation to goods or services, then this application for copyright protection of the artwork will have to be accompanied by a search certificate from the Trademarks Registry, where the Trademarks Registry has concluded that no similar logo is registered as a trademark. Sorry,
Yes.
may continue.
Yes, and additionally, this application for copyright has to be filed within 1 year of issuance of the search certificate that Meghna just mentioned. Also, if, of course, the work is created by more than one people, then you require an NOC from all other contributors. And if you have to, of course, apply with 2 original and identical copies of the work. If at all any picture or an image of a person is appearing on the work, then NOC is required from that person as well. Now, like Meghna mentioned, the copyright register can be rectified. In that scenario, the registrar of copyrights or an aggrieved party can move to the High Court and apply for rectification of the copyright register. These are protection requisites. Just actually reiterating what Meghna has mostly covered, is that any work to be able to register a work under copyright, under the Copyright Act, it has to be original. It must consist of copyrightable authorship and subject matter. And the conditions of publication should be such that the work was first published in India, or where the work was published outside India, the author on the date of publication should have been a citizen of India. When the work is published outside India and the author has died on the date of such publication, then he should have been a citizen of India at the time of his death. And in case of an unpublished work, the author on the date of making the work must have been a citizen of India or domiciled in India. This is a reproduction of the fee schedule that is provided by the Copyright Office, which is
fees.
Yes, this is the government fee for all kinds of works. As is mentioned here, it is generally for literary works, musical works, dramatic works is 500 rupees, except for other, except the fee varies for different kinds of works. For cinematograph film, it is 5,000 rupees, and for per work, I mean, of course, it's charged for per application. Thank you. That brings us to the end of our presentation.
Thank you.
Thank you for your patience.
Yeah, thank you, Alka, and thank you, Meghna. I think we have a few minutes, so we can take questions. I believe Anushri Gupta was relaying her question, right, at that time. So,
Yes.
Anushri, can you please
I
go
just put it in the text in the chat. I was asking that is there any privilege given to the children for registration of their literary work in the Copyright Act?
So if I'm understanding your question correctly, if a child has come up with
literary work, yes.
Correct. Can the child make an application for protection of copyright, as in for registration of copyright?
I understand that a child can, but is there any privilege given? Also correct me if the child can register.
No, there's no special privilege given. If he can definitely make an application in his name, we can probably include something from the Guardian as well. But I don't think any special privileges are given to children. There's no distinction made based on age of the author.
Okay. And is there any fee relaxation for a child?
No, the fees are quite standard for literary works, for all works of authorship. Alka, if you can show that slide again, it's 500 rupees for literary, musical, dramatic, and artistic works. And for sound recordings, it's 2,000, and for cinematograph films, it's 5,000. So they've not made any distinction on the basis of age over here.
Okay. So guardian name is required naturally for the children who is under 18, right?
I think it would be better to give it along with the name of the author. I don't think it's a mandatory process.
Okay. Okay. Because the application should not get rejected on the basis that if the child is, young enough and of course cannot meet the, objections or anything which has come up as per the act. So children, of course, cannot handle the procedure.
Correct. No, definitely.
Yeah? Yeah. All right. Thank you so much.
Okay, I'm going through the chat box. There's a question from Jigar Pathak which says, can a group of people get copyrighted if all the members of the group have worked together on that particular work? And if so, what are the ownership norms?
So if many people have worked on something together, that is a case of joint authorship. The person who is making the application will have to specify that this is a case of joint authorship, and all the people connected in this, all the people who were authors will all have to submit an NOC or a letter saying that they have no objection to the registration of this work, and you can have it registered in more than one name.
So, thank you, Meghna. There's a question from Gulab Bhai Rohit. His question is broadly around, where the copyright, patent, and trademark offices are located, right? We have, 4 centers, and he belongs to the Union Territory of Daman and Diu, or Dadra and Nagar Haveli. So, where should or what office should they select when they try to register their copyright?
Daman and Diu. Just give me a moment, I'll check.
if I could just add to this, as of now, the Copyright Office is in Kolkata. There are no regional.
Delhi, Alka, Delhi.
In sorry, my bad. It's in Dwarka, Delhi. I apologize.
It's not divided based on jurisdiction. It is in Delhi.
Okay, similar to the patent office, does it go to a central place and then it's distributed accordingly? Because for patents, although you may file, let's say, you may file, let's say, in Mumbai, but the evaluation could be done in Delhi or anywhere else. Right? It's a centralized system now.
I'm not entirely sure on the patent application process. I will be able to tell you in a bit. Yeah.
Okay. Sorry. Thank you. There's a question from Kaustubh Atelier, which is, please elaborate the provisions regarding certain works to protect under design registrations or copyright. I guess, how do you choose?
Correct. So there are certain works that are capable of protection under both the Copyright Act as well as the Designs Act. Now, if you have protected it under the Designs Act, then you cannot protect it under the Copyright Act. You can protect it under either one of the acts. If it is not registered under the Designs Act and you protect it under the Copyright Act, or you don't register for copyright, but if you make more than 50 items of a product based on that design, then your copyright in that design will expire after the 50th product is made. So in that case, if you're choosing to use an industrial process on this design and create more pieces, we would recommend that you protect it under the Designs Act, because that will give you protection for a period of 10 years and will not expire on the creation of 50 copies, which happens if you don't protect it under the Designs Act.
Okay, thank you. I think there is someone who's asking for your contact details. So if either you or Alka can type in the chat box.
Definitely, we'll do that.
Yeah. I believe we've covered all the questions. Anirban, I believe so. I think you are.
Yes. Somebody has just asked, Akshay Chakrabarti, if an applicant has a spelling mistake while filing the copyright, what should he do?
You can file an application for corrections and make rectifications as well. There's a process.
Ma'am, while uploading the work, I have submitted the application for correction the spelling mistake, but the copyright was registered in the wrong spelling. So now what can I do?
Alka, do you want to take him through the process for rectification? Basically, you can make an application to the Copyright Office saying that you want to rectify the work. There is a specific form for that. I'll just tell you. Give me a second. There is a form 15 that you can file an application under to make rectifications once your work is registered.
Okay, thank you, ma'am.
Just to add to this, this is usually done by the registrar of copyrights for any clerical errors like in name, address, as in your case. It has to be done. I mean, the correction has to be done by the registrar.
Okay, thank you. I think we've covered all the questions, and we are just 4 minutes past our event time. So thank you, Meghna and Alka, for such an informative session. As you saw, we had like 100+ attendees, very interactive session. So they certainly gained a lot of value from what both of you have shared with us today. So thanks so much. Thank you to all the attendees. Yeah, it's our pleasure. So
thanks.
Yeah, and thank you to all the attendees for taking time out this afternoon learning about copyright registration. Meghna and Alka have pasted their email addresses in the chat box, so please take a note of those. And again, a simple call to action, please register at l2proindia.com. It's completely free, and a lot of the material which was presented today, you will find it there along with the resources. So it's an easy to look up format. Right. So with that, we close the session for today. And again, thank you to the ASSOCHAM team for a fabulous organization. Have a good day all. See you.
Thank you. Bye.
Thanks.
Bye.
Thank you, everyone.